Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we're going to be providing another installation to our Federalist Papers series going on number 78. So if you haven't gone back and watched 1 through 77, I know they're on the longer end, ladies and gentlemen, but one of the frequent criticisms from the late and great Justice Antonin Scalia about the modern legal education system is that they don't teach the Federalist Papers. Understanding the Federalist Papers, in addition to the Anti-Federalist Papers, will provide you a very advantageous, very well-rounded understanding of the U.S. Constitution. And of course, understanding the U.S. Constitution is absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Federalist Papers. The version I'm using is provided by the federalistpapersproject.org, but there are multiple institutions from which you can get a paper and digital copy. Go ahead and get both. While you're out there looking, go ahead and get a copy of the Anti-Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 78, this one's one of my personal favorites, just because it's so condemnatory of the modern judiciary department, and it's coming from Alexander Hamilton, which is probably the penultimate hero of the modern legal education system. If he's not the penultimate, if he's not the pantheon, he's certainly among the ranks of the brilliant geniuses who founded our legal system, so they claim. Number 78 is titled, very simply, very aptly, The Judiciary Department, and it's written by Mr. Alexander Hamilton, published in the Independent Journal on Saturday, June 14th, 1788. It says this: To the people of the state of New York, we proceed now to an examination of the Judiciary Department of the proposed government. In unfolding the defects of the existing confederation, the utility and necessity of a federal judicature have been clearly pointed out. It is the less necessary to recapitulate the considerations there urged, as the propriety of the institution in the abstract is not disputed. The only questions which have been raised being relative to the manner of constituting it and to its extent. These points, therefore, our observations shall be confirmed. The manner of constituting it seems to embrace these several objects. First, the mode of appointing the judges. Second, the tenure by which they are to hold their places. And third, the partition of the judiciary authority between different courts and their relations to each other. First, as to the mode of appointing the judges, this is the same with that of appointing the officers of the Union in general, and has been so fully discussed in the last two numbers, that nothing can be said here which would not be useless repetition. Second, as to the tenure by which the judges are to hold their places, this chiefly concerns their duration in office, the provisions for their support, the precautions for their responsibility. And according to the plan of the convention, all judges who may be appointed by the United States are to hold their offices during good behavior, which is comfortable to the most approved of the state constitutions, and among the rest, to that of this state. Its propriety having been drawn into question by the adversaries of that plan, is no light symptom of the rage for objection which disorders their imaginations and judgments. The standard of good behavior for the continuance in office of the judicial magistracy is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. That's a lie. In a republic, it is a no less excellent barrier to the encroachments and oppressions of the representative body. I chuckle. Do you agree with that? Do you believe that that restriction has prevented despotic appointments to the bench? Let me know what you think. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. Go ahead and highlight that paragraph, or that run-on sentence, starting at whoever and ending at them. According to the most central, well, probably not the most, but pretty darn close. Pretty darn close to the framer, the founder most in favor of a centralist government, he's saying, hey, The courts are completely neutered. They don't have the purse, they don't have the sword. You have no reason to fear them. They are the least dangerous to the political rights of the Constitution. Do you agree with that? Do you think that 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 proclamation holds true to today? Did Hamilton have wise foresight, or did he have, well, I don't know, blind or malicious neglect? Naivete or neglect? I think it's the latter, according to his other writings. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse. Go ahead and highlight that sentence right there. No direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power. Another lie. Or another misunderstanding. He was lying. He knew exactly what he was doing. That it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that quarter. I mean, so long as the judiciary remains truly distinct from both the legislature and the executive. If only men were angels. For I agree that, quote, there is no liberty if the power of judging be not separated from the legislative and executive powers, end quote. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. That is, all the effects of such a union must ensure from a dependence of the former on the latter, notwithstanding a nominal and apparent separation. That as, from the natural feebleness of the judiciary, it is in continual jeopardy of being overpowered, awed, or influenced by its coordinate branches, and that as nothing can contribute so much to its firmness and independence as permanency in office. This quality may therefore be justly regarded as an indispensable ingredient in its constitution, and in a great measure as the citadel of the public justice and the public security. Such a liar. The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved and practiced no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Whoa. There's an argument for nullification right there from Mr. Hamilton, one of the founders most in favor of a centralist government. Any actions outside the constraints of the Constitution, the U.S. Constitution, is void. Without this, all the reservations of particular rights or privileges would amount to nothing. Some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. Those of you who are of the school of thought that the Supreme Court is the ultimate arbiter authority are about to be very upset. This is coming from Hamilton. Again, let's go ahead and start this paragraph over. It's one of the best paragraphs in all of these papers. Some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that the doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void, as this doctrine is of great importance in all the American constitutions. A brief discussion of the ground on which it rests cannot be unacceptable. Whoever gets to declare the other's actions void is the superior power, is the superior authority. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. Go ahead and highlight that line. No legislative act, contrary to the Constitution, can be valid. It does not matter if it's legal. If it's unconstitutional, it is not law. It is not binding, and you are duty-bound not to obey it. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. Finally, something Hamilton and I can agree on, something Hamilton and Jefferson would probably be able to agree on, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supported that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority. The job of the court isn't to conjure up ideas about the Constitution, isn't to materialize beliefs about the Constitution, isn't supposed to be the arbiter of morality. Rather, the court is supposed to always be on the side of the citizens, saying, yep, the legislative is overstepping their bounds. Yep, the legislative is breaking the U.S. Constitution. It's not supposed to be, oh, you had troubles, you have a civil case, well, bring it on up to us. No. The Supreme Court, the U.S. Supreme Court, SCOTUS, per Hamilton's explanation, was to act as an intermediary between the legislative and the citizens. And pursuant to the legal doctrine of contra proferentum, which we've done a lecture on, definitely go watch that, one of my favorite legal doctrines, contra proferentum, the court is duty-bound to side with the citizens and to apply the interpretation of the text most in favor of the citizens, to figure out whether or not the legislative body, Congress, is acting outside of its constitutionally provided authorities. That's it. That is SCOTUS's job. Anything outside of that, completely outside the understanding and the purpose of implementation that the founders were purporting to have, or at least what is demonstrated in the Federalist Papers. Okay. The interpretation of the laws is the proper and peculiar province of the courts. Oh, well, got you there, Caleb. Now you sound like an idiot. Watch how he defines interpretation. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. Oh, there you go, Caleb. You sound like an idiot because Hamilton just said they have to interpret. Here it is. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred, the U.S. Constitution. Or, in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents, the intention of the people. If the people's authority, if the intention of the people is what the Supreme Court is duty-bound to apply before any other text, using the same principle that Hamilton was explaining earlier, whatever body has the nullifying power, the nullification power is the supreme authority. If the intention of the people overrides the agendas of the legislative, and the court's only purpose is to enforce the people's intention, then who is the superior authority? Is it SCOTUS? No. SCOTUS's job is only to apply the intention of the people. So who is actually nullifying the unconstitutional legislative acts? Not the court, the people. Nor does this conclusion by any means, and here's where he makes it abundantly clear, nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. Simply put, it only supposes that the power of the people is superior to both. He couldn't put it more clearly. And again, this is going to be top three founders who were such centralists that they thought it was a bad idea for the colonies to have left the crown, for the colonies to have left Britain. That's how badly they wanted a centralist government. So if Hamilton is saying this, imagine what the other framers were thinking, if not explicitly saying. It only supposes that the power of the people is superior to both. Highlight that. You best believe we're going to highlight that. It only supposes the power of the people is superior to both. Go ahead and highlight that previous sentence as well, because it gives context to this very important sentence right here. Okay. And that where the will of the legislature, declared in its statute, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter rather than the former. SCOTUS takes the sides of the citizens every single time. That is their sole purpose, and when they don't, they are not acting in accordance with their sole purpose. They are violating their oaths, they are violating their offices, they are disgracing their gowns, and they are throwing away their gavels. Your sole purpose as a U.S. Supreme Court justice is to side with the citizens, to side with the intentions and the will of the people. That is coming directly from Hamilton. Hamilton being the person most in favor of a bigger government, of someone who would be advocating, yep, we should centralize all of the different powers of government into one branch, into a king. They ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental. Can y'all see why I appreciate this paper so much? It's Hamilton. This is their hero. This is the modern legal education system's hero. And he's saying, hey, y'all are completely wrong. What y'all are teaching now, y'all are completely wrong. This exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other. That happens a lot today, and neither of them containing any repealing clause or expression, like a sunset clause. In such a case, it is the province of the courts to liquidate and fix their meaning and operation, so far as they can, by any fair construction, be reconciled to each other. Any fair construction. The judges do not get to redefine the words that are in the statutes, that are in the codes, that are in the laws. One has to go, one has to stay. You cannot have two contradictory clashing laws acting simultaneously, because it's a double-edged sword. There's no way to be able to be a law-abiding citizen if you're punished for choosing route A, but you're also punished for choosing route B, and then there's no other route. That's not rule of law, that's just tyranny. So that's what Hamilton is explaining here. But it has to be by fair construction. How do you define fair? That's something to hash out in the courts. But at least he's willing to make that recognition. So let's start that sentence over. I'll try not to interject any further, but this is one of the only papers that Hamilton wrote that actually makes sense. That it seems like he's being somewhat honest about true governance and political science. So far as they can, by any fair construction, be reconciled to each other, reason and law conspire to dictate that this should be done. Where this is impracticable, it becomes a matter of necessity to give effect to one in exclusion of the other. I was saying. I got ahead of myself. I apologize. Just let Hamilton speak. The rule which is obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is a mere rule of construction, not derived from any positive law, but from the nature and reason of the thing. It is a rule not enjoined upon the courts by legislative provision, but adopted by themselves as consonant to truth and propriety for the direction of their conduct as interpreters of a law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should have the preference. But in regard to the interfering acts of a superior and subordinate authority, of an original and derivative power, the nature and reason of the thing indicate the converse of that rule as proper to be followed. They teach us that the prior act of a superior ought to be preferred to the subsequent act of an inferior and subordinate authority, and that accordingly, whenever a particular statute contravenes the Constitution, it will be the duty of the judicial tribunals to adhere to the latter and disregard the former. It can be of no weight to say that the courts, on the pretense of a repugnancy, may substitute their own pleasure to the constitutional intentions of a legislature. This might as well happen in the case of two contradictory statutes, or it might as well happen in every adjudication upon any single statute. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body. If, then, the courts of justice are to be considered as the bulwarks of a limited constitution against legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute so much as this to that independent spirit in the judges which must be essential to the faithful performance of so arduous a duty. The independence of the judges is equally requisite to guard the Constitution and the rights of individuals from the effects of those ill humors, which the arts of designing men or the influence of particular conjunctures sometimes disseminate among the people themselves, and which, though they speedily give place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government and serious oppressions of the minor party in the community. Though I trust the friends of the proposed Constitution will never concur with its enemies in questioning that fundamental principle of republican government which admits the right of the people to alter or abolish the established Constitution whenever they find it inconsistent with their happiness, yet it is not to be inferred from this principle that the representatives of the people, whenever a momentary inclination happens to lay hold of a majority of their constituents, incompatible with the provisions in the existing Constitution, would on that account be justifiable in a violation of those provisions, or that the courts would be under a greater obligation to connive at infractions in this shape than when they had proceeded wholly from the cabals of the representative body. That's where you'll find strong disagreement. Because even if you, Hamilton, think it's a whim, even if you think it's ephemeral, you're not the citizenry. You don't know what's best for the citizenry. Only the citizenry knows what's best for the citizenry. So you may find it fleeting, you may find it whimsical. Ultimately, as long as they're not hurting anybody else, citizenry can have their delegate do whatever they want that delegate to do. If you don't like it, don't be part of the union. If you don't like it, don't listen to them. Let the state do whatever the state wants to do as long as they're not hurting anybody else. That right there, that argument in favor of the Congress acting against the will of the constituents just counteracted and contradicted what he said moments ago. And you can't have both. You can't have the Congress making the final say. You can't have the constituents serving in Congress, and you can't have Congress serving the constituents simultaneously. Like he said, that would mean the slave becomes the master. So whatever the citizens want, that's what the delegates to the Congress has to implement. And if the other members to the union don't like it, they can leave, or they can censure the state. Until the people have, by some solemn and authoritative act, annulled or changed the established form, it is binding upon themselves collectively as well as individually. Go ahead and highlight that. It is binding. It is a binding contract. It is a binding document. And no presumption or even knowledge of their sentiments can warrant their representatives in a departure from it prior to such an act. But it is easy to see that it would require an uncommon portion of fortitude in the judges to do their duty as faithful guardians of the Constitution, where legislative invasions of it have been instigated by the major voice of the community. But it is not with a view to infractions of the Constitution only that the independence of the judges may be an essential safeguard against the effects of occasional ill humors in the society. These sometimes extend no farther than to the injury of the private rights of particular classes of citizens by unjust and partial laws. Here also the firmness of the judicial magistracy is of vast importance in mitigating the severity and confining the operation of such laws. It not only serves to moderate the immediate mischiefs of those which may have been passed, but it operates as a check upon the legislative body in passing them, who, perceiving that obstacles to the success of iniquitous intention are to be expected from the scruples of the courts, are in a manner compelled by the very motives of the injustice they meditate to qualify their attempts. This is a circumstance calculated to have more influence upon the character of our governments than but few may be aware of. The benefits of the integrity and moderation of the judiciary have already been felt in more states than one, and though they may have displeased those whose sinister expectations they may have disappointed, they must have commanded the esteem and applause of all the virtuous and disinterested. Considerate men of every description ought to prize whatever will tend to beget or fortify that temper in the courts, as no man can be sure that he may not be tomorrow the victim of a spirit of injustice. Lawfare, he's talking about lawfare there. Well, not necessarily specifically lawfare, but that at any moment, you could be the victim of lawless activity, including lawfare. Victim of a spirit of injustice, by which he may be a gainer today. And every man must now feel that the inevitable tendency of such a spirit is to sap the foundations of public and private confidence, and to introduce in its stead universal distrust and distress. That inflexible and uniform adherence to the rights of the Constitution and of individuals which we perceive to be indispensable in the courts of justice can certainly not be expected from judges who hold their offices by temporary commission. Why not? Periodical appointments, however regulated or by whomsoever made, would in some way or other be fatal to their necessary independence. Why, Mr. Hamilton? I don't take that presumption to be true. If the power of making them was committed either to the executive or the legislature, there would be danger of an improper complaisance to the branch which possessed it. If to both, there would be an unwillingness to hazard the displeasure of either. If it to the people, or to persons chosen by them for the special purpose, there would be too great a disposition to consult popularity to justify a reliance that nothing would be consulted by the Constitution, but the Constitution and the laws. There is yet a further and weightier reason for the permanency of the judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked with great propriety that a voluminous code of laws is one of the inconveniences necessarily connected with the advantages of a free government. No, the opposite is true. For a rule of law to stand, the law has to be minimal, and it has to be layman. Otherwise, the layman depends on a magistracy, priests, basically what we call attorneys, to understand the law for them, which is not a rule of law. That is a rule of oligarchy. That is a rule of tyranny, because you have to depend upon the magistracy to understand what rules that you are governed by. No, that is not a free government. The exact opposite is a free government. Keep the laws minimal, keep the Constitution simple and direct, which is why it's written the way it is. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. No, case precedence is not legally binding. If it is, that means the court becomes the supreme law of the land and overrides Article 6 of the U.S. Constitution. That is clearly not the point. That is clearly not the authority given to the courts. Case precedence, not legally binding. It stands and is binding only upon the set of facts brought before the court in that specific manner. It cannot be elevated, it cannot be cross-applied, it cannot be cross-referenced, because the only place that precedence is binding is in the situation applied to the set of facts that was brought before the court for that opinion to be rendered. That's it. Any authority granted to case precedents outside of that is allowing an override, is allowing a usurpation of Article 6 to the U.S. Constitution. So to avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents. No. Which serve to define and point out their duty in every particular case that comes before them. No. Those rules, those restrictions are already outlined for them. They do not need to make a judge-made law. Apologies, had some technical difficulties, but they do not need to make judge-made law. They already have the rules, restrictions, and regulations put in place and articulated for them whenever they go about making their opinions. Okay. And it will readily be conceived from a variety of controversies which grow out of the folly and wickedness of mankind that the records of those precedents must unavoidably swell to a very considerable bulk and must demand long and laborious study to acquire a competent knowledge of them. It's also not true. Hence it is that there can be but few men in the society who will have sufficient skill in the laws to qualify them for the stations of judges, and making the proper deductions of the ordinary depravity of human nature, the number must be still smaller of those who unite the requisite integrity with the requisite knowledge. But what defines requisite knowledge? Fun fact to know about the founders, virtually none of them went to law school. Virtually none of them had formal legal educations, yet they were able to collect, through independent self-study, enough brilliance regarding law and political science and governance to draft the very governments and documents which provide for our modern-day governments. So if they didn't need a legal education to form the government, why would we supposedly need this requisite knowledge to apply that government? If they could do it without formal legal education, why do we need a formal legal education? Now, does that mean you can be stupid and win in court? Obviously not. But mandating this requisite knowledge isn't an assurance of good quality lawyers. It's an assurance of one quality of lawyer, which is a servant of the court. It's just so frustrating. He knows what he's doing. These considerations apprise us that the government can have no great option between fit character, and that a temporary duration in office which would naturally discourage such characters from quitting a lucrative line of practice to accept a seat on the bench would have a tendency to throw the administration of justice into hands less able and less well qualified to conduct it with utility and dignity. In the present circumstances of this country, another quick side note before we finish up here with Mr. Hamilton's paper, John Adams had also referenced about needing to be a well-learned individual in order to be an attorney, in order to be a lawyer, in order to be a judge. The first individual that he appointed to the U.S. Supreme Court didn't have a formal legal education. So when John Adams, who was very well in line and in lockstep with Mr. Hamilton, said that you need to be well-learned, well-read in order to be a lawyer, he clearly was not referring to a formal legal education, because the person he appointed, it wasn't just to sit on the bench, it was to be Chief Justice of SCOTUS. Did not have a formal legal education. This requisite knowledge is not quantifiable. This requisite knowledge is not enforceable. And when someone tries to propagate that idea to you, all that means is they have an understanding of a law that is so foreign and contrary to what the clear intent is designated as in the document and in the laws, that they have to centralize and monopolize everybody's understanding for their implementation to actually stand or hold any sort of water. So when you're looking through laws, when you're looking through both state and the general government's constitutions, and you're reading from these courts and these supposed lawyers, and it just seems completely 180 degrees from what the actual documents and laws say, you're not the crazy one. They are. Because they're the ones indoctrinated with Mr. Hamilton's requisite knowledge. So you're not the crazy one. They are. And in those in which it is likely to be for a long time to come, the disadvantages of his score on this score would be greater than they may at first sight appear, but it must be confessed that they are far inferior to those which present themselves under the other aspects of the subject. Upon the whole, there can be no room to doubt that the convention acted wisely in copying from the models of those constitutions which have established good behavior as the tenure of their judicial offices in point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective if it had wanted this important feature of good government. The experience of Great Britain affords an illustrious comment on the excellence of the institution. Excellent. So that's all Mr. Hamilton had to say in number 78. If you have any questions about what he said in 78, maybe questions about what was said in the preceding Federalist Papers, or maybe there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have, specifically from that Federalist paper number 78. It is a fantastic paper. He's got a couple contradictions in there, but for the most part, it's good stuff. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.